We do not have enough time today to enumerate all the ways in which the Bush administration has sought to centralize power in the White House. You might say that it would take a book to do justice to that subject. But I'll look for just a few. I've already talked about signing statements. I've talked about expanded executive secrecy. I've talked about claiming the right to bypass laws and ratify changes governing surveillance, detention, and interrogation, enacting on that theory. It's also claimed the right to imprison U.S. citizens indefinitely without charge or trial, at the discretion of the executive alone, and then act on it. Talked about pulling out of a major ratified treaty, the anti-illicit missile treaty, without consulting the Senate, locking down a precedent that will give future presidents the power to dispose of other major ratified treaties at their own discretion. Maybe a president will arise and thinks we should pull out of the UN or NATO. They can do it on their own now. There's also one from Congress, many statutes that add to the president's power. I've already talked about the Patriot Act. Many people don't know that after Hurricane Katrina, Congress quietly passed a law that gives the president much greater power to impose martial law, even if the state governor objects, overturning a 200-year limit on martial law. The Military Commissions Act of 2006 stripped courts of the ability to hear detaining lawsuits against the president, and locked down in statute the president's power to hold U.S. citizens as enemy combatants. Now, not just for Al-Qaeda members, but for anyone who has assisted anyone else who is accused of taking up arms against the U.S. government. A definition that is so broadly written that it can encompass people who assisted the left-wing Black Panthers, the right-wing militia movement, even the people in North Carolina, the mountains of North Carolina, who are suspected of having helped Eric Rudolph, the Olympic Park and abortion clinic farmer, evade federal capture for 5 years. Enemy combatants. The strategy of picking presidential lawyers to fill Supreme Court vacancies has been an integral part of the groundwork that this administration has laid for a long-term expansion of White House power. You know, in 2005, when Bush nominated John Roberts, Harriet Miers, and Sam Alito to fill the first 2 Supreme Court vacancies in a decade, observers outside the executive branch largely evaluated these nominees for their views on social issues, such as worship rights. And lost amid the hubbub then was what I believe to have been an essential factor behind all 3 selections. There were a broad array of very qualified, very prominent, and very conservative lawyers whom the Bush-Cheney legal team could have selected. Tellingly, the administration chose all 3 from a very narrow slice of the conservative legal universe. All 3 were executive branch legal lawyers. All 3 had spent years marinating disputes over executive power from the White House's perspective, and they were thus likely to bring a very deferential attitude and a maximalist interpretation of presidential power to the bench in future lawsuits that may arise over the claims of presidential authority. For the most part, the project to expand presidential power has been the single most successfully implemented policy in this administration. Only on very rare occasions have there been stumbles. Most notably, last year, in the Hamdan decision, the Supreme Court ruled that when it came to military commissions, at least, the president needed to obey a statute passed by Congress and the Geneva Convention, contrary to the legal theories of the administration. But the fallout from that ruling was quickly contained. One-party rule in Congress helped the White House roll back that decision, quickly setting military commissions back up, and more importantly, limiting its ability to spread as a precedent by stripping courts of the ability to hear any more habeas corpus petitions or lawsuits based upon the Geneva Conventions. And crucially, overlooked, only 5 of the 9 Supreme Court justices disagreed with the White House. The other 4, including Roberts and Alito, are an average of more than 12 years younger than 5. And so rather than a final word, the Hamdan decision may turn out to be something more like a last hurrah for the traditional understanding of checks and balances of president's power in national security matters. In closing, when I say the subversion of American democracy in my subtitle, I'm speaking of American-style democracy, the founders' vision of checks and balances that prevent the concentration of unchecked government power. Not democracy per se. After all, presidents, whether they are subject to the rule of law or not, are still elected every 4 years. But I believe that it is a fundamental principle of democracy that if a nation's governing system is going to undergo a change, it should only happen after an informed public debate and a demonstrated mandate from voters. Back in 2000, the Bush-Cheney campaign said nothing about their attitude towards presidential power to voters, even though expanding it would be a conscious and central agenda from their very first day in office. And today, even though the 2008 presidential primary campaign has already been grinding on for many months, with very few exceptions, the candidates from both parties have again volunteered little about their views of executive power and what limits, if any, they are willing to respect on their own authority after voters entrust one of them with the White House. This should change. All the candidates of both parties should go on the record about this issue before Election Day. Aspiring presidents should be required to tell voters what they think now, not after one of them has already moved to the White House. So, I'd again like to express my gratitude for all forum program and to all of you for coming out and listening and fostering public discussion of this crucial issue. And let's